The next matter is Scott versus Kahn. Mr. Domina.
May it please the court, I'm Dave Domina. I'm here on behalf of the personal representative of the estate of Brandy Block because the trial court committed error when it granted summary judgment and dismissed two distinct claims, one for conscious pain and suffering and one for wrongful death. This is an action for psychiatric malpractice. The decedent was a long-term sufferer from two mental illnesses. She functioned well as long as she got appropriate medical care. In fact, she earned a college degree, she had 5 years of continuous employment, she was a volunteer in a school, and she was living a high-quality life. She became the defendant's patient on February 20th, 4 months and 4 days before her death. During those 4 months, she had face-to-face contact with the defendant 4 times. As a result of those 4 visits, he changed her medications 22 times. One of those changes was intended to substitute the drug Effexor for the drug Zoloft. Both of those medications contain a chemical called venlafaxine. Venlafaxine happens to be what was found in toxicology tests in this patient's body at dosage levels of 5 to 15 times normal levels, depending on how you deal with the top and the bottom end of the normal scale at the time of her death. The doctor did not intend to compound, he intended to substitute those drugs, and he didn't do it. The first error the trial court made was that it failed to recognize, really failed to grasp the conscious pain and suffering claim. This patient went from functioning and being effective to living this kind of a life during the final 4 months that she existed. She had hallucinations, she had fears, she couldn't sleep, she was anxious, she was depressed, she lost her job. She caused people around her to call the doctor's office and report that she was ill spontaneously to try to help her. Between the 8th day and the 25th day of July, the last 17 days of her life, she went to the doctor's office herself 6 times, saw him twice. Her mother called twice more as she was crashing downward, and the doctor reports that he didn't see any change in her symptoms and conditions. The people around her did. They documented the hallucination. Her psychologist referred her over to the psychiatrist for more care. He thought the medications were wrong. She had conscious pain and suffering because she was absolutely out of control on her regimen of psychotropic drugs. Dr. Carl Greiner is the expert witness for the plaintiff. He unequivocally testified that she went downward and became sicker and sicker and sicker because of the way the defendant cared for her. The defendant adduced no evidence to the contrary except his assertion that he couldn't see any change in her condition. That's the conscious pain and suffering claim. The trial court essentially didn't deal with it. In the appellee's brief here, the appellee says, well, how can there be a conscious pain and suffering claim when the injury is death? Both the doctor and the trial court failed to grasp the fact that we contend and we've established issues of fact about the fact that this patient went downhill, became sicker, and was living in torment because of psychiatric malpractice. We're entitled to try that conscious pain and suffering claim. Now I want to talk with you about the death claim. The trial court focused on the wrongful death issue. The trial court held that we did not adduce evidence of the proximate cause of death. Dr. Greiner testified in his deposition on pages 119 and 120 that the proximate cause of death was medical malpractice. He testified earlier in the same deposition when asked by defense counsel, he said he wasn't going to give an opinion on the proximate cause of death to a reasonable degree of scientific certainty. But a careful examination of that deposition makes it clear that what Dr. Greiner meant the first time he was asked was that he couldn't say precisely what the mechanism of death was. He could not say for sure that it was a seizure that caused the heart to seize up, it was a seizure that caused the nervous system to close down, it was some other mechanism of death. But what he could say was that the death was the proximate result of psychiatric malpractice, whether it occurred because of a seizure affecting the heart, a seizure affecting the nervous system, or some other way. There was simply no other explanation for this patient's death. Dr. Kahn, the defendant, at one point in his testimony says, well, I think she died of a seizure. I think it was induced by anaphylactic shock to some unknown substance. That's his theory of death. There is no contrary evidence. The trial court appears to have focused on the questions of the defense lawyer the first time through in the deposition and ignored the rest, and appears to have failed to examine Dr. Greiner's report, which is the second exhibit to his deposition, in which Dr. Greiner also is specific about the fact that the care the psychiatrist rendered here failed to recognize that this patient was at risk not only to herself but to her medications and her surroundings and needed to be in the hospital. The acts of malpractice here involve mismanagement of the drugs, failure to recognize the symptoms, failure to consider and evaluate for hospitalization, and failure to hospitalize this patient. This defendant physician saw this young lady within a few hours before her death. On June 25, she was at his office at 5:30 in the afternoon. He wrote an order that said, take the Zoloft off effective tomorrow, recognizing his mistake. She walked home, reported to have walked with a jagged walk, not doing well with her gait. She died lying on the floor in her own kitchen that night. There is no indication here of a crime scene. There's no indication of a suicide. Dr. Greiner says even if there was a suicide, that was the proximate result of psychiatric mismanagement. There is no indication of any other reason for death, but when she undergoes her autopsy and her blood serums and blood tissues are tested, lo and behold, we find that the venlafaxine level in her body is 5 to 15 times normal, a level that the toxicologist says could have caused death. Originally, or initially, the coroner, the pathologist, says the likely cause was the chemical regimen and the venlafaxine levels. Later, after the defense lawyers talked to him, he opines, well, I can't be sure. Confusing again the legal cause of death with the mechanism by which death came to the patient. We're entitled to try the death case too. Thank you.
Thank you.